Sounds good.
All right. Good afternoon, everybody. I'm Gary Sparrow. I'm the Membership Director at the Henry County Chamber of Commerce. And we have another webinar for you today. And I do have with us today Stephen Morris and Kate Thompson with Meadows, Macie, and Sutton. They're going to talk about employment and some legal aspects of the crisis that we're going through right now. And I know they got some great information, a presentation. There will be an opportunity to ask questions. You can do that through the chat feature, or there's also a Q&A option as well. So either one of those, you can ask some questions. And when they get through with their presentation, we'll go to the questions at that time. So you can type those in at any time, and we'll make sure we get to all those that we can. I'm also going to ask both of them to put their contact information in the chat. So if there's something that you want to discuss, maybe not in the open forum, you can reach out to them that way as well. And also, if you missed any of the webinars that we've done, they are available on our resource page, which is together4henry.com. So you can reach, you can take a look at any of those at any time, and this one will be there as well. And I'm sure we'll have some other people joining us, but let's go ahead and get it kicked off. So I'll turn it over to you, Stephen.
All right, excellent. Thank you, Gary. It is a pleasure to be here this afternoon as everyone goes through these challenging and unusual times that we're facing. Kate and I have a PowerPoint to go through with you on some employment law issues and other business and planning issues that this crisis has sort of brought to the forefront for folks. Primarily, we're going to deal a lot with the governor's order, what's in place between now and May the 13th, those restrictions, how that affects your unemployment issues or issues with employees who don't come back or refuse to come back. And again, also some planning and decision making. So with that, I'm going to switch over to the PowerPoint and we will go from there. All right. Let's see. Okay, as always with lawyers, everything comes with a disclaimer. So just a few housekeeping notes as we get going. Obviously today's program is meant to be educational and informative, but nothing is legal advice, and participating in this program does not create a lawyer-client relationship between you and our firm or any individual attorney. Obviously, as we're going to be providing some examples and discussing things, really ultimately up to you, your choices about your business are ultimately up to you unless they're subject, of course, to a government mandate. So those things are a matter of preference. Ideally, you'll use this webinar to be more aware of the issues that you are facing in the current environment. But of course, for any legal or tax or other advice specific to your situation, you certainly want to consult with your own business counsel or tax or financial advisor before taking any course of action. And part of the reason for that, of course, is that we're dealing with a lot of government programs here that, you know, in their current form, they are what they are, but those things are always subject to change. And the interpretation that either the Georgia Department of Labor or the feds may have about something can also change from time to time. And, you know, oftentimes you'll see very similar situations between one business and another yield completely different results. So those are just some things to guard against and our disclaimer about that. So starting tomorrow, we are in a new world again for the second time in 45 days. The governor's order, executive order from April 23rd, runs from May 1st, basically midnight tonight, through midnight on May the 13th. There's been a lot of media coverage. There's been a lot of negative media coverage nationally about the order, with a huge focus on restaurants and bowling alleys and body art and hair or nails and that sort of thing. Once you actually get into that order, though, there are restrictions on basically every person in the state of Georgia as far as what we can or can't do or should or shouldn't do. And there are restrictions on every business in Georgia, an organization, whether it's a nonprofit, religious institution. Depending on the categorization, there are restrictions in place, things that you have to do. So looking at it broadly, for all Georgians, the order requires that you engage in social distancing. And that, simply put, is keeping yourself 6 feet away from others outside of your household. The provisions applying to all Georgians also prohibit gatherings. And gatherings is 10 people at a single location, or anything more than 10 people at a single location. There are more restrictive requirements for restaurants and things like that, but even private gatherings outside of people who are living in the same household, more than 10 in a single location is prohibited. Now, when the state says single location, the devil's always in the definitions on these things. What you think of as a single location may not be what the order calls a single location. According to the state of Georgia, a single location is a space where all the persons gathered can't maintain 6 feet of distance from each other. So if you have a 300,000 square foot warehouse and you've got 15 people there and they're spread out over the facility, that's not a gathering. That's not in violation of the order. If, however, you've got a conference room that you cram 12 people into, that's a gathering that violates the state's requirement. In addition, the order for all Georgians encourages face coverings when you're outside, except when eating, drinking, or exercising. Again, that's not specific to any type of business. That's specific to all Georgians. Vulnerable populations are still also required to shelter in place under the order through the 13th. That definition is very, very broad. It includes people that you may not think of. If you are age 65 and up, you're still subject to shelter in place, just as you have been since, well, for the entire month of April. If you have chronic lung disease, moderate to severe asthma, severe heart disease, if you're immunocompromised, which traditionally, when we talk about that, people think, someone who has HIV or some sort of autoimmune disease. In that definition, the state also includes smokers. If you have a body mass index of over 35, if you're what they call class 3 obese, you are still subject to shelter in place, just as you have been all of April. Likewise, if you have diabetes, liver disease, or if you have chronic kidney disease and are on dialysis, the governor's order still requires that you stay home except to go out for essential services and essential needs, or if you work in a critical infrastructure business. This same provision that requires folks over 65 to continue sheltering in place also prevents, in essence, all visitation, or at least most visitation, to long-term care facilities, nursing homes. So even though things have been relaxed somewhat, restrictions are still in place that are going to make it, frankly, so that you can't go see your mother or grandmother at a nursing facility. On the business side, there are several sections that deal with specific types of businesses. Generally, no business establishment or nonprofit is allowed to permit gatherings. This covers pretty much any type of business entity, including religious institutions, nonprofit organizations, church services, those sorts of things. So again, if you've got more than 10 people in an area where they can't get 6 feet away from each other, that's considered a gathering and is prohibited through the 13th. As far as business restrictions on top of that, when you go through this order, you'll see a lot of language that talks about a business shall do this and shall implement these particular things, and those are mandatory requirements. There's another set of still mandatory, but not necessarily exhaustive list of requirements where they say you shall do these certain things to the maximum extent practicable. And then there's a category of things that they say that you should do. And we're going to go over some of that, but just to give you an idea of the scope of what we're looking at here. Again, most of the coverage on this has been about the restaurant business. And as you can see from this chart, this is anything but going back to business as usual. Dining, body art, movie theaters, salons, bowling alleys, those things have all gotten all of the press, but every single category of business is going to have new restrictions starting tomorrow. The top three you see on that list, restaurant, dining room, critical infrastructure, and non-critical businesses, those are broader categories. Critical infrastructure and non-critical businesses, those two items, every business is going to fall into that. If you've still been able to operate under the prior order, if you're a retail grocery store, if you're a healthcare provider, then you're critical infrastructure. If you're non-critical infrastructure, you've still got rules that you have to follow. Then when you get down below that red line, that's where we talk about, in addition to those things for whatever category you fall into. And we've tried to put the categories that are generally considered non-critical businesses in red on the slide. So, for instance, if you're offering in-person, in-room dining, you've got 39 new rules you've got to follow and 3 that they suggest. In fact, everybody's got 3. If you run a small retail business, which of course is considered non-critical, most categories, you've got 21 rules that are mandatory that you've got to follow. Actually, in any business operation where you're conducting anything in person. So even just an office that's not generally open to the public, you've got 21 things you've got to do and 3 things that you should do. But if you're retail, they're going to tack on another 7 to that. And even grocery stores actually have more restrictions starting tomorrow than they had prior or that they currently have. And of course, gyms, fitness centers, all that listed there, are as above for being non-critical plus those additional rules. Likewise, dentists, optometrists, those kinds of service providers and professions, you're required to follow the guidance from your professional board or association about that. And of course, swimming pools, entertainment venues, amusement parks, and bars are still closed. That hasn't changed and isn't likely to change, for a couple of weeks at least. So what I want to do is go through and take you through for non-critical businesses and retail with the additional things you have to do in retail, just to give you an idea, because I think that's going to cover the broadest scope of the membership of the Chamber of Commerce. And, in those businesses, you may not have gotten much guidance from elsewhere. So let's take a look first at what all non-critical businesses have to do. This order, by the way, is available online. If you search for, Georgia Executive Orders 2020, this one will come up and you can get a complete copy of that. But just running through what any non-critical business, regardless of whether you're retail or an office, has to do, you've got to screen your workers. If you're reopening and having in-person contact for fever, cough, shortness of breath. If you are retail, or if you're open to the public, you now have to post a sign saying that if you exhibit symptoms of COVID-19, including fever, you cannot enter. So that sign needs to go up if you're in operation and you do retail. If somebody shows signs of illness, there's no allowing somebody to just tough it out. If they are sick, obviously sick, you're under a duty to send them home and to tell them to seek medical attention. Enhancing sanitation, essentially that's disinfecting services, keeping things clean. Same with disinfecting common services regularly. If you've got a break room for your employees, that's something that needs to be cleaned regularly. Requiring hand washing or sanitation by your employees within the business. And there's no guidance on how often that you've got to do that, but essentially reminding your employees and make sure you tell your employees that yes, before you have contact with folks, you need to go ahead and wash hands if at all possible. Prohibiting gathering of workers during hours. Again, if you've got people in the building and they're all on break and you've got more than 10 in a break room, that's something that you're not allowed to do anymore. And that sort of follows along on number 8, which of course is permitting folks, if you don't already, to take their breaks outside or in their personal workspace at their desk so that they can maintain proper social distance. So those are the first 8. And of course, that's a lot to sort of take in, but that's, again, a requirement for any business or organization that's not deemed critical even if you're an office and don't really have a retail operation, although again, if you're retail, you do have to have that sign. But we're not done yet. There's more. Most folks who are still operating, and our firm as well, you've got to implement teleworking for all possible workers. In other words, between now and the 13th, if you've got folks who are teleworking and can still continue to telework and function, you're supposed to continue doing that. It's not really the point where, depending on how you read the order, that you can mandate that, everybody come back into the building. Implementing staggered shifts, if possible. Holding all your meetings virtually whenever possible. We've all become better at Zoom. Intangible services remotely, discouraging anybody from using anybody else's phone or desk or office, work tools, any of that. Handshaking is now a thing of the past. It may eventually come back, but we're all nodding and acknowledging each other from across the room now. And you've got to minimize your person-to-person contact. You're also obligated to put notices at the entrance to the workplace or other areas where they're likely to be seen, whether it's break room or bathroom, that encourages hand hygiene. What you're used to seeing at a fast food or a quick service restaurant about employees must wash hands. That sort of reminder is also required under the governor's order. If you've got property that you're leasing, and this really mostly applies to leased property or even hotels, if you've got hotel meeting space, you're required to enforce social distancing of people that don't live in the same area or don't live in the same household. So again, and that really probably, for instance, in the hotel business, to the extent that you've got folks coming in, signage, notices at check-in, that sort of thing is something that you probably want to look into for that kind of leased property. And we're most of the way through the list. So the last set of requirements for any business, critical or non-critical, or really just non-critical. If you can provide alternative pickup, and a lot of companies are doing this. For instance, and it's a food service thing, but this past weekend, Scoops and McDonald's was open. It was the pickup window outside, and so you're able to do that. But even for non-food businesses, if you've got the option to have alternative points of sale, if it's permitted under Georgia law, they're requiring that be something you try to implement. Cash registers, 6 feet apart. If you go into a grocery store, chances are you're going to see every other register, to the extent they're open. That's the standard now. Point of sale equipment, if card readers, that sort of thing, frequently cleaned and sanitized. Again, there's no specific standard for how frequently, but it needs to be done regularly. Increasing physical space between workers and patrons, it's mandatory, but at the same time, that's something that, depending on your business, the extent and how far away you can keep folks, of course, is going to depend on the specifics there. And for most folks, this has been the case for the last month already, but stopping the use of pin pads. Most credit card merchant services agreements and companies are allowing that, obviously now, and that's been in place, but that's going to continue in place at least through the 13th. So that's the 21 things that every non-critical business has to do. The list for critical businesses is 17, and most of those are similar items. And those are mandatory, again, whether you're running an office, whether you're running retail operation, if it's not otherwise covered, it's not considered a critical business, you have to do those things. If you're running a retail operation, there's some additional things on top of that you have to do that might be a little bit surprising. And first one of those on this list, and again, this is on top of what we've already discussed for non-critical businesses. If you're in retail, you can't have more than either 50% of the fire marshal capacity for your space or more than 8 patrons per 1,000 square feet. Now, the good news here is it doesn't say the lesser of those two things. It gives you the option to calculate it either way. For restaurants, it's even more, well, for restaurants, I believe it's 10 patrons per 500 square feet or 1,000. So, but in retail, non-food retail, non-critical, again, 8 patrons per 1,000 square feet. So if you've got, for the sake of the math, a 1,000 square foot consumer area that's open in your business, 8 people. And it doesn't matter if it's a family group of 4 and 6 others, or excuse me, 4 others. Within that 1,000 square foot, that's as much as you're allowed to have. If it's a 25,000 square foot facility, obviously you've got a lot more freedom there. But if someone asks and someone checks, you need to have an idea of how many you've got in and out to make sure you're in compliance. So, that's something you definitely want to look at. That's something from an enforcement perspective. If you get folks who come looking, and there will be folks who come to look, whether they're officially, from the state or whether they're just concerned citizens, to make sure you're doing what you're supposed to do, you need to have some way to know that you're not in excess of that capacity if you've got a retail operation. You've also got to encourage patrons to use hand sanitizer upon entering. And there's an asterisk on hand sanitizer there, and there's a reason for that. Since this order came out, I think there's some folks explained to the governor that getting hand sanitizer right now may not be the easiest thing in the world for every business. Folks have run out. Distilleries have made a wonderful second line of making hand sanitizer. So earlier this week, the governor issued another proclamation that changed the definition of hand sanitizer. Hand sanitizer in Georgia is now defined as any substance that is typically used to remove pathogens, which basically means soap on up to actual hand sanitizer. So if you don't have it, can't get it, you don't have access to it, that definition is much broader than what it used to be. Obviously, encouraging non-cash payments when possible, sanitizing your entrance and exit doors at least 3 times a day. And this rule seems aimed at those businesses that don't have automatic doors, but even if you have automatic doors and nobody touches them, again, the requirement is that you do it at least 3 times a day. Obviously, I would recommend, before open, sometime in the middle of the day, and then sometime, late afternoon, depending on your hours. Encouraging workers to report any safety and health concerns. That's kind of a normal thing that you do, but you may want to document again that yes, we've actually put something out to our employees that we want them to be healthy and safe. And if they've got any concerns, health concerns or safety concerns, they need to let us know. Installing protective screens or other mitigation measures where there are interactions likely. If you've been into a grocery store lately, you've seen plexiglass shields at cash registers. This doesn't spell out that level is required necessarily. But again, what you want to do is mitigate the risk of close contact between your staff and any patrons that come into the business. And of course, number 7, providing additional hand sanitizer within the business. And again, that's not necessarily hand sanitizer. Soap at this point is also acceptable. One thing sort of going back up to the first item on this list that I want to point out, just to make sure folks understand. The limit on occupancy in a business is patrons, not everyone in the building. So if you have 4 employees in a business, they don't count towards your total of people that you're allowed to have in the retail building. That is customers only. So, when you're making that calculation or determination, that's something to keep in mind. So, in addition to those things that you have to do, the 21 things that you must do for any business or office that's not critical, the additional 7 you have to do if you're a retail business, or the additional 13 if you're a different kind of business, or the mandatory 39 for food service. There are 3 shoulds contained in the governor's order. And these are not mandatory, but they're certainly suggested and recommended. Providing personal protective equipment that's appropriate to your workers within the business location. Certainly if your employees making masks available, although in my experience, most employees want to bring their own. That's something you can do if that's appropriate. Providing them with disinfectant if they've got a workstation, that's certainly something that you can provide or make it available, even if it's not individually to that employee. Look, if you want to disinfect your workstation, it's available here, that sort of thing. And of course, increasing physical space between workers at the work site, 6 feet. And that goes back to that general provision, frankly, that's required anyway under the order, that folks maintain 6 feet of distance whenever they possibly can. From an enforcement perspective, I've gotten reports from clients that even prior to this going into effect tomorrow, they've had some off-duty law enforcement or some law enforcement folks come see them and explain to them that, you need to change this or that because it's not going to be compliant because, we can shut you down. And while that's true on one level, the actual order requires that they give you reasonable notice, give you 2 citations before they can shut you down. But a police officer, someone enforcing this, does have the ability after issuing those 2 citations to shut you down for noncompliance through May 13th. So if somebody comes in May 1st and says you're out of compliance, ticket you, they come back a day later, ticket you again, and you're still not in compliance, at that point, without a whole lot of process, they can go ahead and just shut you down. Hopefully it won't come to that. Most of these things now some of these things are common sense. Some of these things are extremely burdensome and may, make it so that you have to make some decisions about whether it's even worth it or not to resume in-person operations. But again, that's one of those business decisions that in this strange environment you find yourself having to make. Now that we've sort of dispensed with parts of that order, just some employment law issues that you need to be aware of that have come up since April, or actually since late March. From the employment law side, most employment laws tend to leave small businesses alone or exempt them. In late March under the CARES Act, we saw something absolutely the opposite of that. These laws were only applicable to businesses with less than 500 employees. There was a lot of lobbying done. Even McDonald's on behalf of their franchisees tried to get that changed so that they wouldn't get hit with these new requirements. Unfortunately, that wasn't effective. So getting directly into that, under the CARES Act, there are 2 things that may apply to your business with less than 500 employees, or actually that will. One is the emergency family and medical leave expansion. Again, less than 500 employees only. If you've got more than 500 employees, this doesn't apply to you. And there is an out provision here that says for very small businesses, if you've got less than 50, the government may exempt you from the requirement. I haven't looked to see if they've actually managed to do that yet, but there is a safety catch there if you're smaller than 50. So the trigger for this expanded benefit, this employer paid benefit, is if you've got somebody who was working for you for at least 30 days prior to this, and they can't work or telework because they have to take care of their son or daughter who's under 18 because that child's school or place of care has been closed or is unavailable due to the public health emergency, then that employer is obligated to provide them with 10 days of unpaid leave without terminating them, followed by employer paid leave at 2/3 of the regular pay, up to $200 a day or $10,000 in total. But we're hopeful that most much smaller businesses are not going to have this applied to them. But if you have less than 500 and you've got folks who cannot telework or work because they've got to provide childcare because the childcare is closed, then that's something that you've got to do. And that's a brand new thing that, of course, employers now it's mandatory that you pay for it. There's a rebate mechanism we're going to talk about in a second, but that is employer paid leave that has to happen. The second provision in the CARES Act that applies to companies with less than 500 employees, and there is no exemption for very small businesses here, is the Emergency Paid Sick Leave Act. And the Emergency Paid Sick Leave Act requires that your business provide paid sick leave for anybody who has to be out for a qualifying reason, up to 80 hours, actually not up to 80 hours, well, up to 80 hours for full-time employees, and the 2-week of average of the hours for your part-timers. So if you got somebody who averages 20 hours a week and they get sick with coronavirus, you're obligated to give them paid leave. If you're self-employed, interestingly enough, you can also qualify for this paid leave. If there's enough cash in the business, you can actually pay yourself sick time out of the funds of the business under provision of this act as well. What kicks this off, this paid sick leave entitlement, is if they can't work or telework and they're subject to a quarantine or isolation order from the government, not stay at home, an actual quarantine order. They've been told by their healthcare provider that they need to self-quarantine, or they're having symptoms and actively seeking treatment, then you have to pay sick leave for that time, up to the requirement. The cap on that is $511 per day, or $5,110 in total for that employee. But that is something that the employer now has to pay, and that's a new burden that as a small business owner, you've never had to face before. Even if you offer sick time, is something that you're going to have to do. That same act also applies if that person has to take sick time to care for someone who has been ordered to quarantine, their providers, closed due to COVID-19, or they're having a similar condition. The paid sick time under that is less. It's $200 per day, or $2,000 total. But again, it's still required that you as the employer offer that and that you pay it. And failure to do so, is going to impose fines and penalties on you. The way the government's decided that they're going to pay for this, or help you pay for it, presumably, is that they're going to give you a credit for wages paid on your quarterly employment tax returns. And of course, that amount that you actually pay in that tax probably isn't going to, amount to the total that you paid an employee who had to be out and qualified and that you paid sick leave for under this process. So what they do is you're allowed to withhold that portion that's actually attributable to wages being paid in that quarter, the tax rather that's being paid in that quarter. The rest, if there's an additional balance in that quarter, they actually say they're going to refund to you. The rebate for anybody self-employed who gets sick pay under this is by a self-employment tax credit. This is one of those things that if you've got employees who are getting sick pay under this or leave pay under this mandatory requirement, make sure you talk with your accountant so that you can document this appropriately and so that you can actually get that money back. Because again, you're going to have to prove to the IRS that you paid those things for that purpose. One question that we've gotten is, what if I reopen my business and my employees refuse to come back? What do I do? And the answer to that is, well, it depends, which is always the answer with lawyers. Can I terminate somebody if they refuse to work? Well, maybe. And usually that question really means, can I terminate somebody who refuses to return without either having to pay unemployment or facing any issues? And the answer there, again, is maybe. Can an employee refuse to just come back? Can they still get unemployment? Are they going to hit my unemployment insurance rating? It depends, but under current circumstances, probably. An employee is typically disqualified when they leave employment voluntarily without good cause. That's a provision that's been in Georgia law for years. And traditionally, if someone claims a medical issue, then, unless it's shown that it's actually work-related, that, I have asthma and this is a high particulate environment, that's why I can't go back. Unless it's something like that, they're typically denied. We haven't had much experience with people filing unemployment on, refusing to voluntarily return, but I would imagine that that's probably they're going to err in favor of granting benefits at this point in time. Another good reason not to return is if you're in a non-critical business and the employee is in one of those vulnerable categories, over age 65, class 3 obesity with a BMI of more than 35, smoker, immunocompromised, any of those things, they're still required to shelter in place. They can't legally, under the order, come back to work. So, you know, if you terminated someone under those circumstances, certainly they're going to have good cause to be able to go out and get unemployment. And frankly, if you've got more than 15 employees, I would be concerned that a plaintiff's attorney out there might get a hold of them, because at that point, when you've got that many employees, the Americans with Disabilities Act applies. And if you're considered someone to be disabled for purposes of the act, then you're in violation of that act if you don't reasonably accommodate them. So there's at least an argument there that if you terminate somebody who's subject to a shelter in place without trying to accommodate, that could possibly trigger an ADA claim. This is kind of a new area, but that's something that, you know, you want to be cautious about. And one of the things, of course, is a business owner or businesses worry about, you know, well, if I'm not restarting operations and people are on unemployment, you know, even if I've furloughed them or, you know, we've cut back on hours, you know, are my people going to be taken care of? And right now, in many cases, the system that's been set up through federal legislation at this point is extremely generous. A couple of changes, and one that I want to highlight, you know, right at the top, is if you cut hours, not total shutdown, but if you've cut hours so that people are partially unemployed, you are now required as an employer to file a partial unemployment claim for that person with the State Department of Labor. Their website is very easy to use with that, but anybody who has had their hours either temporarily reduced because of a lack of work because of COVID-19 and is expected to return to work when the emergency ends is eligible. And as the employer, you've actually got the burden to go ahead and file that for their partial unemployment. Essentially, the state doesn't start deducting from their unemployment benefit until they start making more than $300 a week on those reduced hours. For folks who are out, you know, completely or unemployed, or who have a partial claim actually as well, again, the Fed's extremely generous provision right now, what's something called the FPUC, the Federal Pandemic Unemployment Compensation, basically adds $600 a week for anyone who's getting any unemployment through July 31, 2020. A problem that we've seen, and you hear anecdotal stories about, is that for many employees, this actually makes it more profitable for them to stay out or to be out than to come to work. You know, small business owners ran out and tried to, you know, keep operations going and went out and got PPP loans to the extent they were available. And, you know, if you've got employees who are making less than about $24.13 an hour, chances are between the maximum Georgia unemployment benefit of $365 and the extra $600 a week, they're looking at $965 a week. So to the extent that you're getting pushed back on calling some people back, that may be the reason why. There's another provision, of course, that adds 13 weeks to PUC. And one other item that's a new pandemic unemployment assistance through the feds. This is the first time the feds have created a basically unemployment for those folks who are self-employed. If you're a 1099 contract worker, gig employment through, you know, Uber or Lyft, something like that, or if you're just self-employed, there are actually unemployment benefits that are available to you through the federal government. But what you have to do to get those is you have to apply for regular unemployment through the state of Georgia, just as anybody else would who is an employee of someone else. They have to deny you, of course, for that, and then the Georgia Department later will consider whether or not you're eligible for those additional federal funds. So if you're a 1099 or self-employed and you found, you know, your business, you know, in the tank because of this, that's something certainly that you want to look at. That benefit's out there. It's unclear, you know, as to how tight they're going to be on some of that. But again, go through the Department of Labor process, apply for regular unemployment. Once they kick it out because you are self-employed, they will consider you for pandemic unemployment assistance, which I believe is about 13 weeks of benefits. One other issue sort of outside the unemployment, but really two. One question that I get from folks is, if somebody gets coronavirus, is that workers' comp? And based on what we've seen and the guidance we've seen and the Georgia definition of a qualifying illness due to employment, workers' comp generally is not going to apply to somebody who contracts coronavirus, even if they contracted it at the workplace, because there's community transmission. However, one other issue, of course, is what do I have to report to OSHA? OSHA requires that you record, or at least originally they were requiring that you record COVID-19 as an illness that's workplace related. Guidance from the administration came out earlier this month. If you're in healthcare, if you're an emergency responder, or you work in a correctional institution, the employer still has to make the standard determination of, is it possible, and it sort of errs on the side of the employee, that this was work related and it's reportable, and we have to report it to OSHA. If you're any entity outside of that, the only reason that you would have to report an employee with coronavirus is if you have evidence, subjective evidence, that it was work related, in the sense that, let's say, you have a department in your business and everybody in that department shows up with COVID-19. In that case, that's a work related outbreak. Chances are you're going to have to, you need to report that. If, however, you have a couple, one or two employees over the course of days in different departments, or that don't work closely with each other, come up with it, that's more likely than not community transmission, and that's not something that you need to report to OSHA on your forms. So, that's obviously a lot of material on the order itself, employment law issues, unemployment, and sort of OSHA reporting. That's sort of a lot to digest. But that's my portion of the presentation. Right now, I'm going to hit the next slide and turn you over to Kate Thompson, who's going to talk to you about some issues that typically you don't like to think about or don't want to think about, but this particular crisis has caused people to give a little bit more thought to. So take it away, Kate.
I think all of us are becoming concerned in this public health crisis about our ability to continue to conduct our business and our personal affairs, even in the event that we were to become incapacitated or even die. And sort of mortality is becoming at the forefront of our minds. And so in planning for the unexpected, I've seen sort of an uptick in people calling about wills, powers of attorney for their finances, and healthcare directives for their own personal affairs. And there's another piece of it when you're a business owner, because you also have that business to take care of. And if you were to become incapacitated or you were to pass away unexpectedly, do you have the documents that you need to have in place to allow your business to continue, or to have your wishes as far as the continuation or the winding up of your business sort of handled upon your death or your incapacity. So generally we do wills, powers of attorney, and healthcare directives. A healthcare directive is simply personal, but a will, under a general will, your executor is going to have a pretty broad authority to be able to conduct any business, unless there is another line of action that's set out either in the will itself or in your operating documents. There are some situations where your executor of your will is exactly the person that you would want to be running your business if you couldn't. But there are some situations where that is the exact opposite person of who you would want to be running your business. And your executor being injected into your business might cause problems for your estate, your family, your business, or all three. So it's important to think about what is the best course for your business upon your death, and make sure that your documents that you have in place will support that happening. In the same vein, a financial power of attorney, generally an agent under a standard, form power of attorney will have the authority to conduct your business affairs on your behalf. But the person who you want conducting your personal financial affairs and the person you want running your business might not be the same person. And so it's important to think about that and make sure that your documents have enough clarity for having those people in place to take over in case you were to become incapacitated and unable to run your business for any period of time. Generally, sometimes business plans or operating agreements have sections about the death of the owner or the primary member, however your business is organized, but many don't. And so you kind of have this default of, the executor of an agent under a power of attorney who becomes the person who's in charge, and that may or may not be what you want. So we just encourage people to sit down, look at what they've got, think about what they want, and if you have questions, talk with a lawyer about what you need.
All right, thank you, Kate. As Gary said, we are going to open it up for questions and pop back over into the live view here in a moment. Just in case I can't manage to quite get this into the chat feed, of course, I'm Stephen Morris, and my contact information is on the screen as far as email here at Meadows, Macie, and Sutton, and Kate's is there as well. So if you have any business needs or questions, we'd be happy to work with you. And at this point, let me turn off the PowerPoint and we'll go back into the regular session.
I'll get it into the chat feed, both of our.
Thank you.
All right. Well, first thing, Stephen and Kate, we were asked if the presentation can be made available. If you're okay with that, if you can email it to me, I can make sure we get it
Absolutely.
out. Yeah, we'll get it out on our resource page when we post the webinar. So it will be out there for anyone who would like to get that. I did have a question when you were talking about reduced hours. Does that mean anything less than 40 hours?
It's really anything less than what they've been working. If you've got somebody who consistently works 32 hours a week and you've cut folks down to 16 because you either don't have folks in as much or just reduced business generally, at that point you're obligated. So it really is about the reduction, at that as far as partial unemployment. So
okay, all right. Let's see. This goes back a little earlier in the presentation. Is the business being required to take employee and customer temperatures as a condition of entry?
For regular retail businesses, no, that's not so. You've got to screen your employees, and the definition of screening isn't entirely clear. Certainly, if somebody's exhibiting signs of a fever, you want to turn that employee away, or frankly, that customer away. But that can get in all sorts of factual things with customers. So we would recommend as a best practice to have them check, or bring your own if you don't want to use our infrared. But that's the best practice. Monitoring them, asking them if they felt feverish is sort of the secondary line there. If you can't get or it's too cumbersome to do the other. So.
Okay, I don't think there's a good answer to this question, but what's the best method to verify BMI?
Personally, I developed a don't ask, don't tell policy on that. It's one of those, it's a sensitive thing, obviously. And, it's one of those that if you wanted to send out something to your employee saying, you're still required to shelter in place if you meet these criteria. and just let them govern themselves on that. I don't think anybody wants to be in the business of certainly having a weigh station or scale and also checking people for, cigarette smoke like your mom did when you were 16 when you came home. So, there's a certain point of self-governance here among employees, and you can inform them, but certainly if they decide, to heck with it, I'm coming in, as long as they're not showing signs or symptoms, then chances are you're okay. Likewise, if you're in a critical business, a grocery store, infrastructure, trucking, those sorts of things, even though they're required to shelter in place under those provisions, if they're working in critical infrastructure, they're actually not subject to shelter in place. So they can come to work. They can't go socialize, but they can come to work. So.
All right. Getting back to the quarantine, if somebody's mandatory quarantine and not able to work, if say like a spouse, my wife had to be quarantined, so therefore, since I was in the house, I would have to be too, even though I don't necessarily have symptoms or anything. How would that play into the reporting to work or not able to come to work?
Yeah, at that point, I as an employee, I think you've got a duty to tell your employer, look, if the doctor's order included you being subject to quarantine, I think at that point it extends, at least under the scope of this order, to you being quarantined as well. So I think that qualifies. And of course, if you can't telework, and that's the other thing, if you're in a job where you can't telework and you're quarantined, that's where the provisions about, mandatory employer paid sick time or sick leave are going to come in. But if, your spouse is quarantined and the order says everyone in your household, then you're included.
Okay. And this is actually something I had a phone call about a couple weeks ago. If somebody is afraid to go to work, or they don't think their employer is doing all they're supposed to as far as sanitizing and things like that, where would an employee fall into in that category as far as not reporting to work?
Yeah, at that point, as an employee, you're making a decision and you really kind of, you roll your dice or take your chances. If there's an issue with your employer's workspace or work area where they're not complying with the minimum requirements required by the state order, at that point, you go to your employer and say, look, these are the things that the state's requiring. This is what we're not doing. That has to be fixed, or we need to fix that. But if you've got someone who is just terrified, frankly, and there are a lot of folks out there who are just terrified, in this situation, this circumstance, that can't bring themselves to come back to work because they are just scared. They may not necessarily qualify under Georgia law, under a voluntary quit, because there may not be a objective basis for not returning to work. So if you do that, obviously you're taking a risk of possibly disqualifying yourself for unemployment. At the same time, if there's a reasonable basis for it, I think what we saw during the economic downturn the last time is a lot fewer people were getting disqualified for unemployment than had been previously, because they were erring on the side of the employee. So, no guarantees, but, work with your employer. If it can't be resolved, then, you've got a tough decision to make.
Gotcha. All right. Well, we're open for some more questions. That's all I really have right now. I think y'all must have done a great job of covering everything, because we didn't get a lot of questions. But we do have your information in the chat. So what I'm going to do is I'll go ahead and I don't see any other questions coming in. I'll go ahead and say thank y'all for being with us today and for the information you provided. I'm going to leave the webinar up for a few more minutes since your information is on there. So if anybody wants to take time to copy that down, and maybe you'll get some questions afterwards that people don't want to necessarily ask on a public chat. So we'll leave that up there for a few minutes, but I'll thank y'all again. And if you want to go ahead and sign off, you can. And again, we'll have this webinar recorded and it'll be up on our resource page as quickly as we can get it there.
All right, excellent. Thank you so much, Gary, for having us. It's been a pleasure to be here, folks, and we look forward to helping you or hearing from you if you have any additional questions. Thanks so much.
Okay, thank you, Stephen. Thank you, Kate.
Thanks, bye-bye.